Film कैसे बोले the moment I can ना but ain't it enough? Ain't it even if that sound comes out also ain't that good enough?
For it.
Please, Lordship. Lordship, you can really allow to mention item number 17, Lordship.
Item number 17.
17, Lordship. And for the petition in this case, Lordship.
Okay. You want to do it another day?
Yes. Maybe listed after a week, Lordship. I have some difficulties today, Lordship.
6 and adjournment for the day. List after week.
Lordship. Lordship, item number 14, Lordship.
Item 14.
Item number 14, and for respondent number 2 and 3, Lordship. If I may get all 3 reasons,
You are for the petitioner?
Yes, you
Okay. So, no problem. Respond number 2 and 3. Item number 14. Respond number 2 and 3. 3 weeks time to file an affidavit. List after 3 weeks.
I'd like to mention item number 12, Lordship, on behalf of my colleague. If 3 weeks time we can
For the petitioner or
for state respondents.
for the state respondents?
Item 12.
Item 12. 2 weeks time
3 weeks, Lordship.
for respondent. You are for the state
For the
respondents.
state respondents.
For the state respondents. The prayer is allowed. List after 2 weeks.
3 weeks, Lordship.
3 weeks.
Much obliged, Lordship.
My Mr. Lordship, I'd like to mention item number 9. And for respondent number 3. Lordship, allow me to file my reply 3 weeks time.
Okay. You're for the petitioner?
Yes, Lordship.
Okay. Investigation is not yet completed, right? In this case, probably. Investigation is probably not completed. Oh, it's charge sheeted. Now it is charge sheeted in the meantime. So, you're for the private respondent?
Yes.
You are learned counsel for respondent number 3. 2 weeks time to file a reply, written reply, comma, which is allowed. List after 2 weeks.
Right.
Next.
May I please, Lordship, I'd like to mention item number 13.
Item 13. Okay.
The opposite party has filed their counter affidavit to our IA,
Ah.
so we need time to go to the IA and file our reply.
Reply if any. You're for the applicant, right?
Yes,
Petitioner.
so,
Petitioner.
yes. So kindly grant us 2 weeks time.
Learned counsel for the applicant, petitioner, 2 weeks time to consider filing a reply to the objection filed by the respondents. Objection
Yes,
filed by
sure.
the respondents.
Yes, Lordship.
Prayer is allowed. List after 2
2
weeks.
weeks time.
2 weeks
Lordship.
time. List after 2 weeks. You want me to fix a date? No, it's okay. No problem.
Okay.
After 2 weeks, we'll come.
Okay, Your Lordship. Much obliged.
Please allow me to move one unlisted item in WPC 45 of 2024.
For motion?
No, my lord. Actually, this matter was last listed on 27 May, and he was supposed to come after 2 weeks, but he was not listed.
Can you
Thank you, Your Lordship. I'd like to mention item number 15. Lordship, if the matter can come up after 2 weeks.
It's for orders, right?
Yes.
Lordship, I'm for respondent number 4.
Okay.
Election document.
I'm for the petitioner.
You're for the petitioner? You're for respondent?
Respondent.
Okay. Learned counsel for respond number 2. 2 weeks time. The prayer is allowed. List after 2 weeks.
Lordship, I beg to mention item number 2, 3, and 4 as well.
2, 3.
And 4. I'm yet to find my affidavit. So another.
It's a connected matter, right?
Yes.
2, 3, and 4. You are for the petition.
Additional.
Petitioner.
Yes.
Your reply affidavit.
Yes.
2, 3, and 4. Learned counsel. So and so. Appearing for the petitioner seeks 2 weeks time to file an affidavit in reply. First, comma, which is allowed. List after let it be after 3 weeks.
Yes, Lordship.
So you file it, in the meantime it will come. List after 3 weeks.
Lordship, there is interim.
Yeah.
Interim. Interim is there in WPC 18, 17, and 3.
Interim order is there.
Yes.
It is pointed out by the learned counsel that there is an interim order granted by the order dated so and so. It's always better to mention the reference order. The interim order by so and so shall continue till the next date of listing. It will be like that.
Obliged.
Time on.
May I please, Your Lordship? Lordship, I beg to mention item number 16.
16. Criminal appeal. Don't want to do it today.
Lordship, I'm the appellant, appearing on behalf of my colleague Cricket Honor, who is leading the case, but she is indisposed.
Oh, I see.
So please grant me 3 weeks then. Your Lordship.
Okay, no problem. But he's in jail or or he's been granted bail in the meantime?
He is in there.
He's on bail.
Yes.
It was 10 years imprisonment, so I thought that maybe he may be in custody also. 16. Learned counsel appearing on behalf of the leading counsel, namely
Cricket Honor.
I don't know, 6 2 weeks time, as the said counsel is indisposed. It is submitted that the appellant is on bail. The prayer is allowed. List after 2 weeks.
3 weeks.
List after 3 weeks.
Obliged, Lordship.
For admission, item number 1.
May I please, Lordship? Lordship, I'm for the respondent number 2.
Just a minute. Just a minute. Just give me 2 minutes. Okay. It's about compassionate appointment.
Lordship. Lordship,
Still in process.
yeah, Lordship, on 28th July, the former Home Commissioner, respondent number 3, has,
That's what I was going through.
yes. Lordship, I have a difficulty today also, Your Lordship.
Just a minute.
Lordship, may kindly peruse the last order.
I've seen it.
This cannot go on like this, Lordship.
Agreed.
It's 9 years.
9 years.
9 years. And contempt is pending for 3 years and 1. Lordship, this is absolute disregard to this honorable court. It cannot go on like this.
Contempt is of 2020.
Exactly,
5
Lordship.
years. 5 years. So anyway, so
My father died in 2016. And now last time, both the respondent number 2 and 3 appeared before this honorable court in person. And now they, under oath before this honorable court, say that today they will place the appointment order. Now, my lord, what here in contempt cases and the direction of the court, it does not need any process like in usual course, but every time they are coming and submitting before this honorable court, 4 times the respondent has been summoned by this honorable court, but they did not appear. Now, where will the petitioner go, Lordship? If this judicious court keeps on having leniency, last time they appeared in person, and now today also they have not brought the appointment order. They can appoint 3,000-4,000 backdoor appointees, but they cannot appoint one compassionate appointee. And contempt is pending for 3.5 years.
Ma'am, can you let us see the order?
Yes,
the writ
Lordship.
petition.
It's to be appointed within 2 months.
Let us see
My Lord
the
will kindly come to.
operative part, right? I believe it is para 6, WPC 21, right? 21.
Yes, Lordship. My Lord will kindly come to paragraph 9, the operative portion.
Para 9 of
Yes,
the order dated
this is order dated
WPC
14/2/2020.
Yeah, WPC 21, right?
Yes, Lordship.
Justice anytime.
Lordship will kindly come to paragraph 6.
Yeah, paragraph 6. Having heard the learned.
Having heard the learned counsel for the parties and on perusal of the material available on record, and with the consent of the learned counsel appearing for the parties, I deem it appropriate to dispose of this writ petition at the motion stage itself, with a direction to the respondent number 3, namely Director General of Police, Government of Nagaland, to consider and dispose of the application stated to have been submitted by the writ petitioner immediately after the death of his father on 28/10/2016, praying for appointment on compassionate ground within a period of 2 months from the date of receipt of the certified copy of this order. Now, my Lord can kindly see that the acknowledgement received are at, this is B is my representation.
In the contempt petition.
In the contempt petition. B is my representation.
These are the orders.
As per the direction of this honorable court, I submitted my representation on 18/2/2020.
Acknowledgement B1, right?
Yes, B1 and B2, B1. Two months have become 3 years and 6 months as of
Should
today.
not be. So ideally there should not be any bureaucratic red tapeism, but
Yes, Lordship.
we have to be realistic. Even if we allow for some flexibility or bureaucratic, some red tapeism, but it should not be beyond that point. Otherwise, this, I was mentioning in another matter that in these kind of matters, ideally, there should be an interlocutory application in the disposed of matter itself, seeking extension of time.
Yes.
Then the reason for filing a contempt petition may not even arise sometimes. Anyway, so her grievance, the petitioner's grievance is understandable. So, Madam, you complete your submissions. Then I'll move to.
No,
the
my
other
lord.
side.
Actually, I don't need to submit because it is within the court, jurisdiction of the court, the authority of the court, majesty of this court, and between the respondents. Actually, it is between this honorable court and the respondents, Lordship.
Contempt, as we know, is not a mode of execution, right?
Yes.
It is actually, once it is pointed out, it's between the court, but indirectly, sometimes it comes to be
And now-
executed. That is different matter.
The hardest thing is, Lordship, taking the leniency of this honorable court. If my Lordship will take all the orders, they have been summoned before this honorable court. Just one constable case. And they are appointing other person since 2016. At least 5,000 constables have been appointed through backdoor or so. Since 2016. I have even placed the record before this honorable court when the writ petition was proceeding. Now, Lordship,
Who was the specific direction was, let me refresh again before I come. Again, let's go back to para 6. with the direction to respondent number 3, that is the Director General of Police. The direction is only to the DG Police?
DGP. Subsequently, the Home Commissioner was implemented. Then against the first DGP,
And Home Commissioner was implemented in the writ petition.
no, in the contempt
contempt
petition, in the contempt petition. And
In the
he
writ,
has
in the writ petition, the DGP was respondent number 3.
Respondent.
And the direction was to him.
Lordship. So they submitted before this honorable court that they have already forwarded their case of the petitioner to the respondent number now 3,
Home
the
Commissioner.
Home Commissioner. So last year, in 2024, I was made to implead the Home Commissioner.
Anyway,
Lordship, it is absurd and
Lordship,
the grievance is understandable.
yeah, I understand, and the problem faced by the petitioner, I don't deny that is a gospel truth now. And the proceeding of the contempt in such an inordinate delay, that's also we agree. Your Lordship, after that 20th July, on the day when the respondent number 3 and DG Nagaland appeared, and commitment has been given by the respondent number 3.
They appeared in person.
Yes.
in
So,
person
yes,
on oath they say that they will place
Yes,
the
Your
appointment
Lordship,
order today.
they appear in person.
Now
After
where
the-
will we go?
Please, just as per the direction of the Honorable Court, they appear. And assurance was given by the Home Commissioner. Your Lordship, here, the thing is, right after that assurance, another Home Commissioner has changed. So my prayers, as a court officer, I understand the problem. I mean, the majesty of the court, it should not be treated in such a way. But the thing is, I find some practical, technical difficulties. Now, present Home Commissioner is not yet implemented. So, if the Lordship agree, a short time will be given, and the present Home Commissioner will be implemented.
because they may-
After completion, let the Honorable Court take the further step. That is
But
my
he
humble
himself
submission.
appeared before this honorable
Yeah.
court. The new
After
after appearance,
yes,
Lordship.
Your Lordship, after appearance of the former Home Commissioner, he was out from the department. So there is a problem here. So in order to avoid any multiple litigation, if I feel that I am a humble submission before Your Lordship, that if the procedure is completed first and take the further
Is
step.
that
That
a
is my-
ground, Lordship? Is that a ground?
No.
After appearing before
No,
this
no,
honorable court.
because the present Home Commissioner, he is not implemented as a party in the contempt
But
petition.
that is, it's not a necessary party.
And
They should
after
not
that,
be.
It's a party.
yes,
They should not be made to. I understand, but they should not be made to run around also because
Yeah, definitely.
because
Yes,
because the
I agree.
petitioner does not have control over the reshuffle that might take
Yes.
place at the stage of the
I-
government
I-
with the government, right?
yes, and Lordship,
So we can, even if we implement the next person, there may be another change. That's the discretion of the
Yes.
government, right?
I just,
So it's a difficult
Lordship,
situation for him.
my submission is as a court officer, I don't want to see that we didn't, the proceeding is
I
not
appreciate
disturbed by the legalities. That's the only submission. On the last date, we'll keep whether it's a compliance or if not, the Honorable Court has a ample jurisdiction to take further steps. But as a court, I want to see that we are not defaulted in the procedure at all. So if the Honorable Court contemplated to take action under the contempt law, then without implementing the present officer, we cannot. There will be some technicalities. Who knows? If we give
Yes,
again
very judicious in this case.
to strengthen the
Very judicious.
litigation. So in order to avoid all this, if a short period is given and within that, I'll apprise the court, and within that, the new Home Commissioner will be implemented as a party in the present contempt petition. That is my humble submission.
On the petitioner part, we have to follow the law. But on their part, they have been violating this honorable order for 3 years and 6 months.
been a-
What is the
That's why initially that was my initial remarks, that some racism may be understandable, but it should not be beyond a point. Anyway, please have your seat. I'll need 5 minutes to go through this file. 5-10 minutes to go through a file. This order I've seen, last order. I need to just. There was a direction to file an affidavit, right, about indicating vacancies and all that. That has been filed. There was an earlier order I saw, the direction to file an affidavit, you know.
Lordship, yeah, we have filed earlier it was difficulties of keeping the particulars of the applicants, and now everything has been sorted out.
Because,
And the matter is pending, and
see, there was, because the court direction is always given like that. There was no direction that you appoint him. There was a direction to, you know, consider and dispose of his representation, right? That can always be done. I'm not saying that you dispose of and reject, but that's, the thing is that there's always a, you know, expectation that it will be considered positively. But that was the direction was rather simple, you know. But should not have been caught up in such complications. Like, as I understand from the previous orders, the DGP officers processed.
yes,
DGP officers processed, and it has gone to the office of Home Commissioner.
yeah, and now home to PNR, last stage, final stage. In the meantime, the concerned officer has transferred.
PNR.
PNR.
Lordship,
That is a final stage.
Lordship,
So we may need to implement PNR also. Suppose it gets
Lordship,
stuck there.
all those things have passed. Now I just humbly pray that I'm being told that only now. And again, another new one has been
is my suggestion.
replaced.
That was-
So let me implement that by tomorrow. I'll do it.
That's what he was saying.
I'll do it. I'll do it. Then let them do. By tomorrow, I'll implement the new incumbent. This may be
Contempt petition 24 of 2020. Heard Learned Council. So and so.
is it Jimo?
Who submits that, who draws my attention to the previous order dated 28/7/2025, in which it is stated that both respondent number 2 and 3 of the contempt petition, being the learned DGP Nagaland and learned Home Commissioner Nagaland, had appeared in person, and an undertaking was given by respondent number 3/Home Commissioner that the case of the petitioner shall be considered within a month's time. But it is submitted that despite the said assurance, nothing has happened as on today also. Expressing her frustration, the learned counsel for the contempt petitioner submits that as per the order dated 14/2/2020, passed by this court, 14/2/2020 passed by this court in WPC 21 of 2020, within bracket para 6, on learned DGP Nagaland, who was respondent number 3 in the writ petition, was directed to consider and dispose of the application submitted by the writ petitioner, praying for compassionate appointment. And the said exercise was directed to be done within a period of 2 months from the date of receipt of certified copy of the order. The learned counsel has also drawn my attention to Annexure B and B1 regarding such submission of representation and its due acknowledgement. Full stop. The contempt petition was registered in 2020 itself, as rightly pointed out by the petitioner counsel. Considering that the initial direction in the writ petition was for compliance within 2 months, and no permission of the court has also been taken for extension of the same. The direction still being in a process, as a matter of concern. It's a matter of concern. Learned government, additional government submits that though the Home Commissioner Nagaland was pleaded as respondent number 3 in the contempt petition, but in the meantime, a new incumbent has joined in the said post and is required to be pleaded. The petitioner counsel submits that the petitioner would implead the said respondent immediately. Accordingly, Sri so and so, to be the present learned Home Commissioner Nagaland, may be impleaded.
By way of IA, Lordship.
You may file an IA.
Yes,
You have
yes.
to
By
file
tomorrow I'll file it, Lordship.
may be impleaded, and for this purpose, may have to be impleaded, and for this purpose, the petitioner would be at liberty to file a IA.
Lordship.
However, in terms of the assurance reflected in the order dated 28/7/2025 of this court, it is expected that the remaining process with regard to the direction of in the writ petition shall be completed expeditiously.
Lordship.
Let me just make that observation.
Yes, yes.
So,
Expeditiously, Lordship, at least give the time, otherwise they will take another 2-3 years.
as early as possible. No, that cannot be. In that case, we'll have to, the
This is
court will be constrained to drop, because always, some benefit of doubt is given, because though it is not a mode of execution, but always some liberty and some flexibility, some understanding is shown. But the court also does not like to drop contempt against
Yes, exactly.
a responsible authority. Each one of us is a responsible
Exactly,
authority. Expected to be doing our duty. And as I said, red tapeism, some red tapeism ideally it should not be there. I'm just repeating, but some red tapeism is maybe understandable, especially in developing countries, but it should not be beyond the point. It should not be beyond the point, right? Then definitely the people will be frustrated.
Exactly, Lordship. That is what I have
It is
become.
not counsel's frustration. She is within full her right, fully within her rights to convey the frustration of the petitioner.
Yes, exactly, Lordship.
That is what she's.
I'm fed up of phone calls.
So anyway, as early as possible.
Obliged, Lordship.
As early as possible. So we'll fix it after. When should I fix it? In the meantime, you file the IA.
I will file tomorrow, Lordship. By
File the
tomorrow I
IA.
will file. And however, it has to be
This
passed
matter.
in this main petition. So at least kindly you yourself, when it should be listed. I just want your opinion. So that it will be
Up to 2 weeks.
after 2 weeks, Lordship.
I can give 3 weeks also.
2 weeks, Lordship. At least he's sitting
But
in the
at least there should be some movement.
Yeah,
And
it
then
has to be.
take a decision.
So, Your Lordship, if it is last and final, if it is 3 weeks, because authorized respondent number 3, who is newly implemented. And now, as I again repeat again, the matter is in the final stage, BNR. So in the meantime, I address a newly joined Home Commissioner, respondent number 3.
Lordship, I just humbly pray. I'm also fed up, Lordship. Frank,
Yes.
3.5 years, and as if I don't have any other things to do, and always following this for
That's true.
last 5
Let
years,
it be 2 weeks only.
Lordship. And in the
You want-
event,
You wanted 3 weeks.
3 weeks.
and in the event, they again violate. Lordship, there should be some penalty.
Then,
That is all I.
Then,
pray for.
the thing is that then you draw up a contempt proceeding. What can you do? You have to formally draw up a contempt proceeding in that case. Formally draw. And list after 3 weeks. And
A fixed date may be given, Lordship.
list after 3 weeks on 1st September, right? Today's 1, 2, 3. Let it be on 23/9.
23. Lordship.
You can convey that
Lordship, on 23, I have a fixed matter at principal bench.
No problem. We can fix another
So,
date.
prior to that,
Prior to that, 22nd or 25th. You will have to come back from Gauhati, right?
Lordship,
You have to come back from Gauhati. 25, let it be.
Lordship.
That gives you sufficient time, and you also convey that my position as a state council also becomes inconvenient.
Yes.
Because I understand your difficulties also. So you convey that you make it easy for me also. Complete the process. Complete the process.
Obliged, Lordship.
For admission, item number 5.
Kindly keep this. Should take it. Oh. Several pleadings are there. Item number 5. This is for admission, right?
Lordship.
Admission.
It appears from the process that the private respondents are represented by counsel. Otherwise, I was asked to take steps about the respondents' work. So if they be deemed to be complete, Lordship.
Just a minute. I think, noticed, I think they have appeared, right?
Lordship.
Notice in this routine. Wakalatnama file. Moaz Zamir, learned counsel, appears for the petitioner. As reflected in the office note dated 27. Oh, it's not 27, it's 27/8, sorry. 27/8/2025. I find that both the respondents have entered appearance to their learned counsels who have filed wakalatnama. This is a delay condonation.
Lordship. Which was rejected by the learned.
Okay. So it was initially filed before district judge. Right?
Yes.
Now it will be in the Dobashri court.
Yes.
So it would have been convenient if someone had appeared, since the counsels are there. Because otherwise, if they are filing any counter, it's okay. Otherwise, we can admit and post it for hearing.
Yes, Lordship. Yes.
Admit and post it for hearing. I can admit it today also, but
Yes, Lordship.
again, if they file a counter, it will go back. So, what do you suggest? Should I admit it? Then?
I leave it to your Lordship. Because Lordship, only the question of law to be decided. So
Yes. maybe we can also, discuss about whether the applicability of section 14, pursuing in a different court. That aspect also has to be seen. But anyway, the present civil revision has been filed by the petitioner, agreed by the petitioner council, village council, agreed by the order dated 20th June, right? 26, 206, 25, passed by the learned additional deputy commissioner. How do you spell this? Chomkedima district. In IA number 1 of 24, within bracket, arising out of appeal number 1 of 2024, bracket close, whereby the delay condonation petition of the petitioner seeking condonation of delay of 819 days in preferring the appeal was dismissed. Upon perusing the pleadings in hearing learned counsel, the revision is admitted for hearing. And stop. In the meantime, the respondents, both the respondents who have appeared, would be at liberty to file their pleadings if any. So, one date should I fix for orders? List after 3 weeks. List after 3 weeks in the orders column. Okay, thereafter it can be fixed for, and you can post it for hearing.
For
You
admission,
can inform them also that we have admitted. If you file, you can file in the meantime.
for admission, item number 6.
Bail application.
Lordship, sorry for the indulgence, Lordship.
No problem.
Item number 10 and 11.
Yeah, 10, 11.
Here the state has filed an affidavit stating that the money, the bill that I'm asking for was funded by the government of India. But the fact remains the order was issued by the state. So, Lordship,
It was funded by the
government of India, that's what they claim to say.
yes.
And they have discontinued with the...
Similar matters were.
Yes, Lordship. Lordship, if this matter can be taken up next week, Lordship, I want to place on record the judgments also. Because the issue is not who's doing the funding, whether I have executed the work or not, Lordship. There are decided case on this issue, Lordship. So, or on Thursday, if my learned friend is agreeable.
Your Lordship,
Next week will be better.
yes, Thursday I have some. This is
Next Tuesday.
Tuesday, Lordship, yes.
Lordship, next Thursday.
10 and 11. Yes, 10 and 11.
Then,
Learned Council. Your Mr. Mozu,
and also, Lordship.
Learned Council submits that in the meantime, the state respondents have filed an affidavit regarding the contractual bills which the petitioner is seeking. And in the context of the same, he desires to rely on some similar judgments and prays for fixing the matter next week.
On 11th, Lordship.
Prayer is allowed. Fix on
11.
11/9 September. Thursday.
fix on 11/9/2025. For it will come for admission.
Lordship, admission.
This is posing some problem because the fund, the scheme discontinued in between. But you are right actually. But the point of view, the person, that the principle of estoppel will also lie because
Exactly.
this is a very, very, what I say, perplexing problem actually. The fund, if it is centrally funded and it is discontinued, then it also poses some problems
Yes.
for the government. At the same time, the person on the other side is not responsible for that also.
Yes.
At the same
In
time.
fact, Lordship, the funding pattern of the state of Nagaland, as far as the state is concerned, it's 90-10. 90 is borne by the government of India.
Many northeastern states.
Yes, almost all the project, Lordship.
So, let's see how these issues can be resolved.
Yes, Lordship.
Lordship,
The legal side.
until and unless at least the person or the government who have sanctioned the project has been put to tax in one of the case. This will continue. This will continue, Your Lordship. The state has been made, one department of the state government has been made as a nodal department to implement the project. And there is a timeline framed under the memorandum that the project should start within these days. We issued a work order as in compliance to that office memorandum issued by the state government, Union of India.
And the funds stopped in between.
And the funds stop in between.
Obliged, Lordship.
Deeply obliged, madam.
Let's see what can be done.
For admission,
Exercise
item
of
number.
jurisdiction.
Obliged, madam.
For admission, item number 7.
Lordship, this item 7 and 8, Lordship.
Same.
Yes, they are arising out of same FIR, they are co-accused, Lordship. However, separate bail applications have been filed for each of the accused. This is an NTPS matter, Lordship.
Commercial quantity?
Yes, Lordship.
Commercial quantity.
Yes. There is violation of Article 22, subclause 1, the grounds of arrest, Lordship. But before I come to that, Lordship, I'll be allowed to take my lord to the FIR. At page 17, Annexure 2. This is a Sumuto FIR. To the officer in charge, Narcotic Police Station, Nagaland, Kohima.
What is the date of the FIR? How come they don't give the date?
5th,
5/5/25.
yes, my lord, 5th of May.
That other file where I dictated. Can you keep this? 5/5/25.
Yes, my lord. Now, Lordship, I may be allowed to read the FIR. I have the honor to state that on 5/5/2025, at approximately 6 p.m., critical information was received from reliable sources indicating that a suspect using mobile number so-and-so was transporting illegal narcotic drugs from Manipur to Nagaland. The information was accordingly entered in the general diary, reference so-and-so. Immediately, superior officer was informed. Subsequently, the MVCP, team of the narcotic police station, was deployed for interception at Pesama village, new reserve area, with technical assistance from TAU PHQ. At around 6:50 p.m., the duty party intercepted a white Xylo vehicle bearing registration number so-and-so. Verification confirmed that the driver was in possession of the aforementioned mobile number. During initial questioning, the driver identified as Sahabuddin. Sahabuddin is the bail applicant in the next bail application, Lordship. Son of so-and-so, so-and-so, from Assam, Lordship, displayed suspicious and nervous behavior. Two independent witnesses from the local colony panchayat were requested to be present during the search. So, Lordship, before I proceed, the present bail applicant, Lordship, he was not present.
He was arrested later
He was arrested later, Lordship, yes.
on his statement.
Yes, Lordship.
Sahabuddin's statement.
Yes, my lord. Two independent witnesses from the local colony panchayat were requested to be present during the search. One, Sri So-and-so, Vice Chairman, New Reserve Colony Panchayat. Two, Sri Tefositniso Silio, Secretary, New Reserve Colony Panchayat. Upon the arrival of the witnesses, a thorough search of the vehicle was conducted under video recording. During the search, suspected narcotic drugs were found concealed inside a modified fuel tank. The fuel tank had been structurally altered to include a secret compartment. Upon dismantling, a total of 30 soap boxes suspected to contain heroin were recovered. The soap boxes were individually weighed and serially marked as follows: so-and-so, so-and-so. The total weight of the suspected heroin amounted to approximately 334 grams. So, Lordship, commercial quantity is from 250 grams under
50
the
grams.
yes,
Heroin
yes,
is
my lord.
5 to 22,250 is
Yes, my lord, my lord.
intermediate
So,
quantity.
this is
21C.
Yes, 21C, my lord. The seized item were duly packed and sealed in a parcel which was attested by both the independent witnesses and the accused. The following items were seized under a proper seizure memo and the entire procedure was videographed. The sealed suspected narcotic drugs, the vehicle, Xylo Nagaland registration so-and-so, one ignition key, one insurance certificate, Sriram General Insurance Policy number so-and-so. A detailed seizure panchanama was prepared and signed by the witnesses and the accused. The accused Sahabuddin was arrested under proper arrest memo following due legal procedure. Owing to the late hour, the accused was sent for medical examination at NHK and subsequently kept at North PH lockup for safe custody. During preliminary interrogation, the accused disclosed that the seized contraband belonged to one Salim at Jilim associated with the mobile numbers so-and-so, so-and-so. This is the bail applicant in the instant case, my lord. Having reasonable grounds to believe that the accused, namely Sahabuddin, has committed an offence punishable under the NDPS Act, it is requested that the case be registered and action be taken under the appropriate provisions of law. Now, Lordship, that day itself the FIR was registered, he was taken under custody.
Same day.
Yes, Lordship.
Both were arrested on the same
No.
day. Yeah. No,
No, no, Lordship, Lordship, that is the bail applicant in the next application.
he was arrested at the spot.
Yes, Lordship, Lordship. Now, Lordship,
Arrest memo. This is, he was arrested on
next day, Lordship.
next day.
Yes, on 6th of May 2025. Annexure 3. The date and time is provided. Now, he has been continuously under custody, Lordship. Bail application was filed before the Special Judge NDPS Act, Kohima, but the same was rejected, Lordship. And now, Lordship, it is well settled, Lordship, especially after Vidhan Kumar has been passed, Lordship, by the Honorable Supreme Court versus State of Haryana, that the grounds of arrest must be served to the accused. And not only served, Lordship, but it must be served in a proper manner, Lordship, as mandated under law, and that it must be served in a language that the accused understands, Lordship.
True, that's settled now.
Yes, Lordship. Now, here, at Lordship, it happens in so many cases, Lordship, which is why I want to address this Honorable Court on this issue, Lordship. It may happen in other cases also, Lordship. What happens in Nagaland is that the grounds of arrest is served, Lordship. Whether it is as per the provisions of law or not, that is one thing, however. It is served in the sense the signature of the accused is obtained by the police at the time of arrest, at the police station, at the lockup, Lordship, or in the place in which he is arrested. Now, Lordship, after that, they don't serve a copy to the accused. They keep the signed copy with them, Lordship. Which is why, Lordship, Annexure 4, page 27. My Lord will find that, Lordship, here also, the seal.
Page 27.
Yes, my Lord. It comes with the seal of the Special Judge NDPS Kohima. That means, Lordship, it was obtained only after the arrest was made from the court, Lordship.
Which one? Annexure 4.
Yes, my Lord, page 27. If my Lord will kindly take the trouble of going to page 27, Lordship.
27.
Yes, my Lord.
I am on 27 only.
Yes, my Lord.
Of this bail petition.
Yes, grounds of arrest.
Grounds of arrest.
Yes, Lordship.
Seal of court. Where is the seal of
Yes, at the top of the page, Lordship. Court of the Special Judge NDPS. Ground of arrest, Lordship.
I think this was made seen later, perhaps. Don't you think this is after it is made seen in the court?
Yes, yes.
No, initially all these documents have to be made seen in the
Yes,
court,
Lordship.
right?
Yes, Lordship.
So might have been at the time made seen also after arrest.
Yes,
at that
Lordship.
time also.
Lordship, what I want to say
Not
is that, Lordship.
necessarily antedated. Not necessarily.
Yes, I'm not saying it is
Prima
antedated,
facie,
my Lord.
prima facie.
Yes, I'm not saying it is antedated. I'm saying that this is a certified true copy, my Lord. It is not antedated. So, what I mean to say is that if it was served to me, I would not have applied for the certified true copy.
Okay. So yeah, the fact that you have to get it from the court means that you were not served. That's
Yes,
what you
my
are trying
Lord.
to say.
Yes, my Lord.
Get it now.
Yes. And it happens in all the other cases, Lordship. But when that issue is raised, the prosecution comes with the argument that, see, your signature is present here, and it shows that you have been served. Now, Lordship, secondly, this is entirely drafted in English. This is important, Lordship. It was not served to the accused in a language that he understands. Now, that is on the teeth of the law laid down in Vidhan Kumar, Lordship. I may be allowed to say my Lord quickly to Vidhan Kumar, paragraph 21, Lordship.
According to you, these grounds of arrest would not be sufficient?
No, my Lord. Because
apart from the language issue, of course. Language issue, leaving it aside for the moment, the contents will not be sufficient. It narrates 4 points.
Yes, Lordship.
I'm just taking your opinion.
Yes, Lordship.
Your
It will not
contention.
suffice. It will not suffice, my Lord. The basic facts, how it has to be served, Lordship, as laid down in Purgayasta's case, my Lord.
Yeah, it should be specific to the grounds and reasons of arrest.
Yes, my Lord.
Reasons of arrest are generic. grounds of arrest are specific.
Yes, Lordship.
That is what has been said
Yes, my lord.
in
my lord.
broadcaster, right? That
Yes,
is
my
how
lord.
we
Yes, my
now
lord.
now we understand. Now our understanding is better. And otherwise earlier we all it was used interchangeably. So
My
now
lord.
the Honorable Apex Court has pointed out a distinction.
Lordship.
That there is a difference between,
Yes, my lord is right.
unlike whatever was taught earlier, there is a distinction now between reasons of arrest, grounds of arrest. Reasons means generic, grounds means specific.
Yes, my lord.
So here, according to you, this four do not satisfy that test.
Yes, my lord.
It does not satisfy according to you.
Yes, my lord. I'll come to that point later, my lord.
Okay.
Now, Lordship, in paragraph 21, paragraph 21p, my lord.
Yeah.
Paragraph 21.
Conclusions.
Yes, yes.
Summarized.
Yes, my lord. It is clearly provided that the grounds of arrest must be provided to the accused in a language that he understands. The accused, he speaks, Lordship, Assamese and Bangla, Lordship. Besides that, Lordship, he has no working knowledge of English. He has never been to an English medium school. And that also, Lordship, Assamese school, he studied.
Hindi. They say anyway, so they said that it was explained in Hindi and Nagamese, right?
But when he has no working knowledge of Hindi, Lordship,
So that is his contention.
Yes,
He does
Lordship.
not have any
Yes,
working
Lordship.
knowledge of Hindi.
yes.
Everyone may not have, definitely.
In Northeast, Lordship, many people don't know Hindi. Yes.
South India also, and it's okay, no issues. Some people, it
And Lordship,
comes
it
from
is
exposure.
also clearly laid down in Purkayasta's case, Lordship, that it must be served in writing. That means if in a language that he understands, if the state is taking the ground that it was explained in Hindi, then this grounds of arrest also should have been served to him in Hindi, Lordship.
And in Bihan Kumar that has been clarified that it is not always because this writing prescription was in the context of UAPA in that case, broadcaster. When in Bihar Kumar it has been clarified, if I am not wrong, that it can be oral also, but provided there has to be a contemporaneous record, say in the case diary or something, that it was conveyed. But in the supplementary opinion rendered by our Justice
Potishwar,
I think it is again mentioned that it has to be in writing.
Yes.
Anyway, so paragraph 21 summarizes the law.
Yes, Lordship. In paragraph 2 of N. Koteshwar Singh's decision, Lordship, in the same judgment, it is clearly written that, Lordship, it must be served in writing, Lordship. And also, Lordship, section 48, informing a relative must be complied. These are mandatory provisions, Lordship. But 48, it has been totally violated. There is not even a semblance of compliance with section 48 of PNSS, Lordship. Now, Lordship, on the language issue, I would like to rely on a decision passed by the Honorable Supreme Court, a short judgment, Lordship, only 2 paragraphs, and a recent decision passed by this Honorable Court, Lordship, the principal seat. But I would like to take my Lord to the decision passed by the Honorable Supreme Court first. 1980, 4 SCC 427, Lordship.
Okay, which para?
The first para itself, Lordship.
Okay. The preventive detention case.
Yes, Lordship. That the detainee was served with order of detention and grounds thereof in English. The detainee does not know English, and therefore the detainee could not understand the said grounds of detention, nor he was given any copy of the grounds of detention. duly translated in vernacular language. It was the duty of the detaining authority to have supplied the detainee in the original language or at least in Hindi. 2. Controverting this allegation, the Undersecretary of the Government of India stated that grounds were explained to the detainee by the prison authorities. In the affidavit, the name of the authority concerned or the designation is not mentioned, nor is there any affidavit by the person who is stated to have explained the contents of the grounds to the detainee. The Undersecretary further suggested that as the detainee had signed a number of documents in English, it must be presumed that he was fully conversant with English. This is an argument which is based on pure speculation when the detainee has expressly stated that he did not know English. Merely because he may have signed documents, it cannot be presumed that in absence of cogent material that he had a working knowledge of English. It is also in dispute that a translated script of the grounds were supplied to the detainee at the time when the grounds were served on him. This is undoubtedly an essential requirement as held by the court in so and so. In these circumstances, therefore, there has been clear violation of the constitutional provisions of Article 22.5 so as to vitiate the order of detention. The petition is therefore allowed the continued detention of the detainee being invalid. He is directed to be released forthwith. Lordship, I may be allowed to place a single decision, Lordship. There are other decisions also. Decisions passed by, yes, Justice Mitali Tapuria, by Justice Kosami, Lordship. Bail application 1173 of 2025, a decision passed by Justice Robin Fukan on 3rd of June 2025, Lordship. I may be allowed to read some paragraphs from this, Lordship. Paragraph 13, my Lord, at page 5. It is also to be noted here that the effect of non-communication of the grounds of arrest is well settled by Honorable Supreme Court in the case of Prabir Purkayasta, so and so, so and so. In the case of Vihan Kumar, Honorable Supreme Court has in no uncertain terms stated that if an arrested person is not informed of the reasons for arrest in a language they understand, then the arrest becomes illegal. It is also held that failure to inform the grounds of arrest to the accused, relative, or nominated persons under Section 50 of the CRBC, now Section 47 of BNSS, also renders the arrest illegal. In the case of Vihan Kumar, Honorable Supreme Court has also held that for any such violation, they must be released from custody. It also went on to hold that even if statutory restrictions exist, constitutional violations override such restrictions, and courts can grant bail in such cases. In paragraph 15, they have relied on a decision passed by the Honorable Supreme Court. I may not read this, my Lord, on the same question of law, Lordship, in order to save my Lord's time. In paragraph 16, Lordship, it is fact that the aforementioned proposition was laid down in the case of an accused who was kept under detention under sections 1, so and so of the Preventive Detention Act. But the said provision is equally applicable in the case of accused under other penal statute, also as Honorable Supreme Court has discussed about Article 22(1) of the Constitution of India in the said case. And as such, this court is of the view that the ratio laid down in the aforesaid case also strengthened the submission of Mr. So-and-so learned counsel for the accused. Now, after this, Lordship, the accused has been enlarged on bail, Lordship. So, my Lord, communicating the grounds of arrest, Lordship. Here in the Supreme Court decision in Hari Kishan's case, which the learned single judge has relied on, Lordship, it speaks about grounds of detention, Lordship. But here also, the learned single judge has observed that grounds of detention and grounds of arrest, Lordship, both must be served to the detainee or the accused, Lordship, in a language that he understands. And when that is not done, then the arrest is vitiated, Lordship. Now, Lordship, my Lord is very well aware that the recourse of Section 37 exists, Lordship. Now, this Honorable Court in Nazipur Rehman, I may be allowed to rely on paragraph 31 and 32. Be that as it may, paragraph 31. I may be allowed to.
31 and 32.
Yes, my Lord, 31 and 32. Be that as it may, non-compliance of Article 22, subclause 1 of the Constitution of India being clearly established in the present case, the arrest of the accused person is totally illegal and is vitiated. That being so, the recourse of Section 37 of the NTPS Act shall not affect the power of this court to grant bail to the accused petitioner. Hence, I shall be failing in my duty if the accused petitioner is not released forthwith. Therefore, on this score alone, further detention of the accused petitioner in custody is totally unjustified. After that, Lordship, in 32, the bail conditions have been laid down, Lordship. This is a decision passed by Justice Goswami, my Lord.
Nowadays they are following it, of course. Nowadays they are following, but even because by and large they are following it. But earlier these things were, awareness was not there, and so they were in standard formats. This was done. But but even now, suppose today there is an arrest, or this was in May actually. If there is non-compliance with these provisions,
Yes, Lordship.
serious offences, then it's a procedural lapse definitely. Because now we are expected to know, the investigating people are now expected at this stage. This law has been there for a while now, couple of months. So now they are expected to know and follow it.
Lordship,
But earlier it was not there. It was
Yes,
not,
Lordship.
earlier, if you go back earlier, in none of these, it was in standard formats. Anyway, so
in Lordship, in Nur Muhammad versus State of Assam, where commercial quantity of
yes,
NTPS was,
yes,
yes,
it has been held in Vihan Kumar only.
Yes, Lordship.
If there is violation of 22
Yes, Lordship.
constitutional provisions, then statutory provisions like 37 or 43D of EOPA would not come in the way.
Yes, my Lord. Now, Lordship, coming back to the grounds of arrest again.
Because constitutional provisions are more important. They are on a higher pedestal,
My Lord.
as we know.
My Lord. My Lord, coming back to the grounds of arrest again, Lordship. As my Lord has rightly pointed out, Lordship, this grounds of arrest is not in conformity.
No, I'm not saying about this. I was just seeking your opinion. That I won't say, but I'll hear her. But in many previous, last year or earlier, they used to be in standard forms. But here, it is not completely bland. Also, they have written a few points. So
Yes,
the
Lordship.
question is whether that will suffice. or
Yes.
not. According to you, it does not. But
No, basic facts is missing.
we have to
Lordship.
decide.
Yes,
Our court has to
Lordship.
decide whether it suffices.
Yes,
Because
Lordship.
this is after a few months after these laws have come.
Yes, Lordship.
6/5/2020.
Yes, Lordship.
They have written. This is the IO
Yes,
is not. It's not a case of the IO not being completely unaware.
Yes,
The IO has written in the grounds of arrest itself, in accordance with Article 22(1) and Section 47. Anyway,
Now, dear Lordship, the basic facts, Lordship, has not been properly laid down. If I may be allowed to read, Lordship. 1, Lordship, the specific grounds of your arrest are as follows. 1, that you are found to be involved in act in contravention of NTPS Act and PNS 2023. 2, that sufficient material and evidence has been established against you in NTPS so and so, so and so. 3, that your custodial interrogation is considered necessary for the purpose. Now, this can be considered as a reason for arrest, Lordship, not the ground of arrest. That your actions is punishable under sections 21C, so and so, 2023, Lordship. Now, the basic facts, Lordship, the offences, Lordship, except for the mentioning of the section, Lordship, that
There's 4 points.
yes, the term of imprisonment that he will be suffering, Lordship, or if, Lordship, if the section 302 of IPC relates to murder, then at least the IO can say that, Lordship, you are charged with the offense of murder, or you are charged with the offense of possessing commercial quantity of so and so, which is punishable with so and so years under the Act. That has not been provided, Lordship. And that, Lordship, regarding Apu Salim's statement also here, because here is a case where I was caught on the statement of somebody else. That fact is irrelevant here. That is also missing in bail application 7, Lordship. So it cannot be said that the basic facts exist, Lordship. And on this ground, Lordship, I pray that the accused person may be released on bail on stringent conditions, Lordship, to the satisfaction of my Lord. I am deeply obliged.
Submission on the other one is also same.
Yes, Lordship, yes.
Grounds
It's
of arrest
It's identical, Lordship.
should I have a look? Identical.
Page 25, Lordship. Except for the change of particulars, Lordship. Everything is the same, Lordship. It's copy-paste.
So, Your Lordship, this is the status.
Investigation must be going on, or it's
Yes, Your
over?
Lordship is still going
It's
on.
still going on.
Still going on.
Would you like to submit?
Yes, Your Lordship, as far as the ground of our arrest is concerned, Your Lordship, yes, I have to make a first submission. I have to assist this honorable court. So, Your Lordship, on inquiry, Your Lordship, I was informed that this ground of arrest was actually given to the accused person. They were informed and they were made to understand in the language they understood. In a sense, they were made to understand in Hindi language and as well as Nagamese. It seems that the accused knows Hindi as well as Nagamese, so they were made to understand in that language, Your Lordship. My learned friend has already stated that, like, the accused, it should be in the language they understand, and it should be given to them, Your Lordship. The thing is that when an arrest is made, Your Lordship, it should be, Your Lordship. And when I ask, like, whether it has been made in a correct form, because it has to be made under Section 47-48 of the BNS Act, Your Lordship. But unfortunately, that has not been complied with, Your Lordship.
48.
The 48 and 47, like making an acknowledgement that I was meant to understand in the language that I understood.
That is be
That-
better.
Yes, Your Lordship, that is there, Your Lordship, that format is there, but unfortunately, in
It
this
was not
case,
there.
Your Lordship, when I inquired, yes, this ground of arrest was definitely
Fair,
taken, Your Lordship,
fair
it's definitely taken. However, when I inquired
That way,
about that acknowledgement and
That would have
informing
been
to the third
perfect.
person, Your Lordship, unfortunately, that form was not being complied with.
Has
So,
48 notice been given?
48 and 47, Your Lordship, BNS said
48
that
was not given.
That was not being complied. Acknowledgement that
Okay, no, 48 notice to relative, it was not
that is
given.
also not being complied with. I mean, like, that is what
It's
I
not
know
in the
for-
case diary, it
It's
seems.
not in the case diary.
So, no, anyway, it's a factual matter.
Yes,
You
so.
know, fact is a fact. We should
Yes,
not be
Your-
afraid of
you
facts.
know, yes,
It's
Your
there,
Lordship.
it's there.
I
It's
have
not
to
there,
make,
not there.
I have to make a fair submission.
Yeah, absolutely.
And it's my duty
I
to.
appreciate that.
It's my bounden duty to assist the court. So, Your Lordship, I am informed that this ground of arrest was taken. It was given, he was met to understand in Hindi as well as in Nagamis. However, as I have stated, as section 47 and 48, yes, there's a format, and that is not being complied. That is there, Your Lordship.
Nowadays, they make good formats.
Yes,
I've seen
there's a
some.
procedure,
Must
there's
be
a
here
format.
also.
Otherwise, Your Lordship, the ground stated here, Your Lordship, there might not be actually very specifically that you have been booked under this and like because of this offense for possessing. But that specification may not be there, but they have already stated the sections, Your Lordship. So I think the ground that they have stated here should suffice, Your Lordship. That is my submission, Your Lordship. And secondly, Your Lordship, section 37, Your Lordship, if at all we succeed that this ground of arrest is to be taken, then my another ground should be that mandatory period has not been over. And therefore,
That's quite long in commercial quantity.
yes, it's a
180
commercial
days.
quantity. It's a
180
commercial quantity. Therefore, Your Lordship,
Which can
if-
further be extended to 1 year.
yes, Your Lordship, if at all, Your Lordship, I
6
succeed
months.
on this ground of arrest,
Okay.
that this is a sufficient.
Then we have to see 37.
Yes,
The applicability of 37.
Yes, the applicability of 37 is that, Your Lordship, mandatory period is not over, and therefore.
And no, the 37 is that he's not guilty.
Yes.
Prima facie not guilty.
Yes.
Which is a very tough test.
Yes,
You know, it is tougher than I've dealt with UAPA cases when I was in NIA court. So UAPA, the language is on the basis of the materials, the court has to hold that he is prima facie not guilty. It's not the materials, the acquisitions are prima facie not true.
yes,
But in 37 NDPS, you have to hold that prima facie not guilty.
Yes.
This test is higher.
yes, Your Lordship.
It's a tougher test.
It's a, yeah.
Easier
It's a-
for prosecution, tougher for defense.
Yes, Your Lordship.
Anyway.
So my line of defense is, Your Lordship, on these two, Your Lordship, that is by submission and. lastly-
48 notice on the face of it is not there, it seems.
Yeah, on the face, that format, Your Lordship, it is informed, that is what I am.
Informed, but in the format it's not
in
there.
the format, Your Lordship, that, the procedural, that format is not being complied. And Your Lordship, in the event, Your Lordship, if this honorable is of the opinion that the accused should be granted bail, in the event this honorable is of the view,
Alternative submission.
then, Your Lordship, my submission will be again strict. Conditions should be given, and at least a government servant, because now, Your Lordship, the IO is of the apprehension that if they are released on bail, Your Lordship, there's high chances, probability of
They are from
absconding also,
Nagaland.
Your Lordship. So, Your Lordship, a government servant, Your Lordship, at least should be a surety, Your Lordship. And a strict, Your Lordship, condition should be.
That's true, fair enough.
Yes, Your
You
Lordship.
have a right to make that.
Yes, Your Lordship.
Yeah. So time is also up. So,
Yes, Your Lordship, so.
I could have dictated here, but I think since time is there. So,
Your Lordship, so the order will be out today or tomorrow?
yeah, should be.
Okay.
I will dictate today only.
Okay.
But I would have dictated in the court only, but I think time is up.
Oh, Your Lordship.
So I think after having lunch, I can
Yes, Your
dictate inside.
Lordship, the recurse of 37 shall not be attracted when grounds of the Article 22(1) is violated.
Yeah, if the court
Is satisfied.
is satisfied that 22 has not been compliant, then that does not come.
Yes,
It prevails over that.
yes, my lord.
If my
prevails
submission
over
survives, then 37.
Yeah,
applies.
then 30. 37 is a very tough test.
Yes,
Yes,
You know, in this case of Watali, which is the leading case on the interpretation of bail in UAPA. Of course, now subsequent decisions have also come. It has been clearly said, reference has been made to NDPS 37, and it has been held, it has been said by Honorable Supreme Court that the test of not being guilty is higher.
Yes, Your Lordship. I will leave it to the judicious mind.
Lordship, in the grounds of arrest, Lordship, what has been caught, how much has been caught, Lordship, that is also missing, Lordship. That is the basic facts.
Yes,
my lord, it's missing.
I'll go to it again, think about it.
In Sakib Chowdhury, Lordship, this Honorable Court, Justice Kalita's decision, Lordship, has held that those basic facts must exist, Lordship, in paragraph 36. And in
Have you submitted? I'll go through. You've given so many citations, and I'll go through.
My lord.
If necessary, I will reserve the order and
And
bring it
bail
out tomorrow.
application 2 of 2025, the Kohima Bench decision, Lordship. There also, Lordship, similar observation was made by Justice Devashish Padua. I can furnish that bail application too, my lord. No basic facts, Lordship. Besides the language, Lordship.
Yes.
Lordship, and if this instant application is allowed, Lordship, and I'm very optimistic about it, Lordship, if the government servant can be from Assam only, Lordship, because these are not people from Nagaland and it will be difficult for them to find government servants from Nagaland. They have no relatives here, Lordship, no family members, no friends.
They are from Nagaland.
Yes, Lordship, from Assam.
Okay.
My lord. Much
A
obliged.
proper ID. If a government servant with proper ID, Aadhaar card,
Yeah,
then should be
let's see. Yeah, I think I will dispose it of. I'll try to give the order today only.
My lord.
Otherwise, if it is not completed, I'll keep it for tomorrow.
Yes.
My lord.
But definitely within tomorrow.
Yes.
My lord.
I wanted to dictate here only, but that's time is up.
Okay.
Okay.
Much
Deeply
appreciated.
obliged, my lord.
This hearing matter will be done. 18. Oh, we'll do it after lunch.
Lordship, my senior counsel's name is not reflected in the council list. If it can kindly be reflected in the order, at
Okay,
least.
okay.
Yes, I'll give the name. I'll provide
Yeah,
the
no
yes,
problem. Surely, sure.
I am deeply obliged.
Sure.
My please, Your Lordship.
Yeah.
My sincere apologies, Your Lordship, for the indulgence, Your Lordship. But if I may be allowed to make a mention, item number 18, Your Lordship.
18.
Yes, Lordship. I make a mention on behalf of the leading counsel for the appellant, Lordship.
Appellate.
Yes,
You
Lordship.
want
Yes,
to
sir.
do it another day?
Yes, Lordship, after 3 weeks, Lordship.
After 3 weeks.
The respondent counsel.
I had seen the file actually.
Yeah,
It's
Lordship.
not very, only 2 points are involved. It's
Lordship.
like, the income and the consortium. We could have done it today. Anyway, as you wish.
The leading counsel for the respondent is also absent.
Okay.
Yes, he's taken leave. So,
Learned Counsel, Mr.
M. Ferro, on behalf of BN Sharma.
B.N. Sharma, 6,
3 weeks time.
after 3 weeks.
Lordship.
6, an adjournment of 3 weeks, further submitting that. And the Learned Counsel for the respondents are also on leave today. Prayer is allowed. List after 3 weeks. You want me to fix a date or just like that?
Just like that, Lordship.
List after 3 weeks for hearing.
Lordship. Much obliged,
We'll
Lordship.
do it on next day. You just,
Lordship.
just do it. 2 points, consortium and income.
Income. Lordship. Much obliged, Lord.
Unlisted matter.
For admission from the supplementary course list, item number 19.
Supplementary has been published on the basis of the unlisted.
May I please, Your Lordship, this matter was last listed on 27 May 2025.
Yeah, let me just have a look at this order. I see. Okay.
I may be allowed to read out the order.
Yeah,
Dated 27/5/2025.
2025. Yes.
Heard Mr. So-and-so, learned counsel for the petitioner. Also heard Mr. Zeden Muli, learned CGSE, praying for the respondent number 1, 2, and 3, and who submitted that as per direction of the court, he has already taken steps through the respondent number 2 to the respondent number 4 to 7. The notices have been duly served and acknowledgement has been received. Accordingly, however, affidavit could not be filed at that regard. He accordingly sought for 2 weeks' time to file affidavit. Prayers is allowed to list the matter after 2 weeks, enabling the learned CGC to file affidavit. But after 2 weeks, he have not filed till now, and the matter has not been listed till now. So the petitioner.
That is why you mentioned.
Yes, Muller.
Let me just understand. There are 7 respondents, right? So CGSE is representing 1, 2, and 3. And this army
And the private
people,
respondent is serving under the establishment of respondent number 2.
Okay, all are 4 to 7 are private respondents.
Yeah, private respondent.
I see. Brigadier Gulerian, so and so, Khatri, Ankita Dhiman, village. Okay, they have been served.
Yes, respondent number.
They have been.
We have record to serve
affidavit
notice
filed
for
on-
respondent number 4 to 7 to respondent number 2.
Learned
Who is the
CGSE is
CGSE?
here to file affidavit, rejoined affidavit file for steps upon respond number 4, 5, 6, and 7. True respond number 2. I see. Oh, they have been served.
Yes, as per the submission of the learned CGSE.
Yes, they have been served.
But he have not filed the affidavit in that regard.
But they have not filed any
Yes,
affidavit in opposition, right? What is the matter?
The matter is regarding his annual performance.
I'm also saying, it's just,
Yeah,
let me see the prayer portion.
his prayer.
Should not be issued, impugn speaking order passed by the impugn. Service matter.
Yes, Mula.
This one, this jurisdiction of Armed Forces Tribunal won't come. No? This will be here.
Yes, this will be here, Mula.
The service matter pertaining to defense, right?
Yes, Mula, this is regarding his annual performance report.
I see. Because after the AFT has been set up, service matters pertaining to defense go there usually. So this may be different.
This is the second time the petitioner
Let them
reports.
hear, let them say, let them have their say. Then we can, it was filed in 2024. Right? Because
My humble prayer is that this honorable court allow direct the CJC to file affidavit and to list the matter along with the review petition, which the petitioner have also filed since his incumbent juniors are promoted this year. So in that regard, we have filed a review petition 4 of 25.
review petition in the judgment.
Here, in this honorable court.
So this is seeking review of the Oh, it was dismissed.
IA
was
we filed
dismissed.
IA, but the IA was disposed.
Okay.
So to challenge that IA, we have filed one review,
I
4 of
see.
25.
I see.
So this petition was supposed to come up with review, but it was not listed.
Can I have that order? This one, disposing of the CGSC is not available now. It's not
Yes, madam.
Please sit down. I will take some time. Have a seat. Sit down. Let me just go through and understand the matter. Okay, so in the meantime, while you had filed this IA to get a stay of the promotion, they already, the DPC was already convened and people were promoted, right? So therefore, the court held that it might have become infractious. Okay.
Yes, no, actually, we've asked for the this year DPC, but the learner CGSC, he submitted the previous year DPC report. So there was misleading of the Sonoma court. For that we have prayed for
So
review.
actually, you were seeking stay of the 2025 DPC.
25, yes, but he submitted the
I see.
2024 DPC.
I see. Okay, let them reply then. Huh?
Yes, madam.
Let them reply. So presence of the CGSC would have helped anyway. So kindly write. Review petition first. I'll give the order. The review petitioner has filed the instant review petition seeking review of order dated 24/4/2025 passed in IA Civil 4 of 2025 in connection with this writ petition, right?
Yes, ma'am.
In connection with WPC 45 of 2024. Full stop. It is submitted by learned counsel. You know his name. Learned counsel that Pakin, your good name.
I'm Pakin Richabong.
Oh, yes. Mr. Dev is the leading counsel.
Yes, ma'am.
And no, we'll record your name. Submitted that the impugn order in the review petition, which had held the interlocutory application to be infractious, was passed on certain incorrect facts placed before the court, and therefore the petitioner seeks review of this order. Full stop. The respondents hearing all the three respondents hearing, you have served copies on all 7. The 3 respondents hearing have been served copies as reflected in the order dated 21/8/2025. However, none appears today on behalf of the respondents. In the review petition, pro forma respondents are required to be served. Notice was sent of this also.
It was not record for the performer respondent in the review petition.
At this stage.
Yeah, only the 3 respondents.
However, none appears for the respondents, 3 main respondents. So, list the review petition after some time. No?
My Lord, I'm praying for the main writ petition to list along with the review petition.
Yeah. List this review petition along with WPC 445/24. It will be listed together.
The review petition was listed 2 weeks ago.
Okay.
So, but the main writ petition wasn't listed.
Yes.
So now I'm praying
yeah,
the writ petition be listed along with the review.
From now onwards, the writ petition and the review petition will be listed together. This review petition, within bracket, review petition 4/25 shall remain tagged with WPC number 545/24.
Yes, Madam.
This is the order in the writ petition, in the review petition. As far as writ petition is concerned, heard learned counsel who has drawn my attention to the last order dated 27/5/2025. The learned CGAC JN had accepted notice on behalf of the respondent number 1, 2, 3. Had accepted me. Is representing respondent number 1, 2, 3. Further, it is reflected in the said order that notice upon respondent number 4 to 7 within bracket private respondents was also taken. Steps of notice upon so and so was also taken through the respondent number 2. Who's respondent number 2? Director General of Assam Rifles. And that notices have been duly served and acknowledgement received. Full stop. Thus, I find that apart from the respondent number 1, 2, 3 being represented by CGAC, learned CGAC, the private respondents have also been duly served. Full stop. However, none appears today on behalf of any of the respondents. Full stop. this writ petition, being WPC 45 of 24, shall remain tagged with and listed along with review petition number 4 of 2020. List after, you tell me how.
My lord, on my inquiry with the registry, I'm told that the major is supposed to come on 19th of September.
Oh, he's on leave.
On 19th of September, this review petition is listed.
Oh,
I mean, in
on
in the
19th of
records, yeah,
September.
19th, yes.
So let us fix it on the same day.
Yes,
Can we fix it on the same day?
Yes, ma'am.
List on 19/9/2025. Review petition, there's a date. Oh, I see, 4 weeks. 4 weeks, okay. 21/8. So review petition, I need not pass an order today. Should I pass it? It was not fixed today. Review
No,
petition.
review is not fixed.
Oh, I see.
I'm only praying for the main petition.
Oh, then we need not pass actually. I unnecessarily dictated. Then only this would do. Sorry, ma'am. Was it? It's not very long order. No? Review. It's a short order. Then this will remain. You know, this writ petition being so and so shall be tagged with review petition 4 of 25 and listed together. As per order dated 21/8/2025, passed in the review petition, it was directed to be listed after 4 weeks. So we'll fix a date for the writ petition.
Yes, ma'am.
List on 19/9/2025 along with review petitions.
Yes, ma'am. Yes.
So that will make it sure that review petition is also coming on that day.
Yes, ma'am.
Along with review petition. So review part will you just cut. This will be okay.
No, I'll reply, ma'am.
Just in the meantime, kindly let us do that homework, okay?
Yes.
And that because let them also, they will also have their say, of course, because Armed Forces Tribunal looks after service matters of defense people, but Assam Rifles actually it's paramilitary, but under the Defense Ministry. The Director General is a military officer, as far as I know. Yeah. The Director General is a Lieutenant General, usually, as far as I know, subject to correction. But technically, it may be a paramilitary, so therefore, it may not be before Armed Forces.
I'll reply.
So 19/9, we'll see together. On 19/9,
Yes.
both the matters will
Yes,
be
ma'am.
taken up together. No more?
I'll reply.